Welcome everybody. I want to welcome to the third edition of the Lunch and Crunch. And I want to introduce our two speakers today, Joe Hogan and Josh Bell. They're going to be covering the topic for us. We are recording this session for anybody who does happen to miss it at your firm that is interested in seeing it. Just wanted to give you a heads up as far as Q&A is concerned. You should have a Q&A box. If you do have any questions for our speakers, please type them in, and we will get to those at the end of the session. So with that, I will turn it over to Joe Hogan.
Well, good afternoon, everyone, and welcome to this episode 3 of our Lunch and Crunch series. We're really pleased to be able to present these to our membership and other guests and friends. And we're particularly pleased with the partnership that we have now with Document Crunch. I'll talk about that in a moment, but this episode, as you know, is about public work prompt payment retainage. Last month we did private work prompt payment and retainage, and I want to say now that as we begin to plan for next year, this will be our final episode of the year, as next month we will be live at the industry conference reprising the program on notice. And that's in Saratoga Springs in early December. But as we plan for next year, if you have any particular requests of topics you would like this team to tackle, please let me know. So Josh Bell is the Director of Industry Solutions for Document Crunch. Of course, I'm the VP of Building Services. And as I'm reminded as I look at my picture, that's an old picture, and I need to update that. Nonetheless, as I said, we're really pleased to partner up with Document Crunch. AGC New York State has a history of providing tools to help our members better manage their business. And the partnership with Document Crunch allows for a very important tool relative to contract documents. It enhances what we've done for a long time on spec review, as many of you know about. And with that, I want to turn it over to Josh to talk a little bit about the Document Crunch program and what's available for the AGC New York State members with a special discount.
Yes, thanks, Joe. Basically, Document Crunch is going to simplify the contract so you have hyperlinks to specific topics. So today, for example, we're covering public prompt pay and retainage, and we will show you how Document Crunch will just identify those things in the contract, so you can just click on the hyperlink and see what it says about that. Now, that has been customized for AGC New York members. So we have basically in partnership tailored that to make it New York AGC specific.
And I think one of the important pieces of this, so we kind of call it a project manager cheat sheet, because it does two things. One, it will identify some of the issues, some of the concerns, and of course provide commentary on key topics from AGC New York State with, as Josh said, the New York State perspective. It'll give some ability to look at some of the clauses and maybe have some suggestions on improvements to that. But at the same time, make sure that at a project manager's fingertips, they have knowledge of where some of the hot button issues are they need to take to look at. And so, the issue of payment, as you will see, particularly on public work, is an important piece of that. So let's dig into it and talk about prompt payment and generally and how it interacts with New York State law on public work. And we'll dig into retainage, and then a particularly important area is going to be payment at substantial completion and what happens at that point in time. So we'll look at, this is what's typical as you see the issue of payment. It's gonna bring up this kind of a document. This happens to be the AIA document, whatever document you ask to be reviewed, it will look at that. So Josh, why don't you talk about this piece?
Sure. Yes, as Joe mentioned, it's basically document agnostic. So whether it's AIA consensus docs or some like customized, it's going to find the same things. It's going to identify these payment provisions, provide a rationale and insight as to what they are, and the rationale and insight sample language to provide some alternatives, and that has been tailored and customized for AGC New York. But when you upload these, as Joe mentioned, Document Crunch's goal is to empower everyone to understand what's in their contracts. So we want to do this and simplify these things, and by providing these things, it's all organized in like a table of contents to, in this instance, like payment terms. You can just click on that and see what the contract says about these things and identify all instances of that. And also it's going to identify what's not there. So it's going to say not found if there's something that isn't in the contract. So you can identify that as well and quickly to see if it needs to be there.
So what's interesting here is you look at this particular slide. Looks again, this is a typical AIA document, as you know. There are folks that want to bastardize this document with supplementary conditions that will often supplement this, but sometimes they miss that. So what's interesting here is they look at a day of the calendar month to submit that application for payment, and then it says the owner is going to pay no later than 15 days after accepting such application. And what's interesting as we look at this on the public work side, as we move to the next slide to get the rationale and view that you'll see, is the public work law in New York State. So when we're looking at state agencies, authorities, public benefit corporations, except New York State DOT, although the law is similar other than retainage, which we'll talk about in a bit, they're governed by state finance law, section 139F. Local governments, school districts, and the like are governed by section 106B of general municipal law. And both laws are largely the same, in that the contractor is to be paid, less retainage, which we'll talk about, within 30 days of the requisition. And after that point, the contractor is to be paid interest for every day payment is late. Now, what's kind of a nuance in the 30 days, there's a slight difference between state finance law and general municipal law, but it's important for you to understand this. So under state finance law, that 30-day clock starts ticking when the requisition is delivered to the state. So, if your contract document says the initial delivery goes to the designer or to a construction manager as agent, paying attention to the timing of that going to the state officials becomes important to know when that 30-day clock starts ticking. You don't have to know that, however, if you're talking about local government work, anything governed by general municipal law, in that the clock starts ticking upon delivery to the owner's designated representative. So if your contract document says that you're going to deliver the payment requisition, other than the pencil rec, but the actual requisition goes to the designer. The moment that goes to the designer, then that 30-day clock starts ticking. Now, there's a slight difference if you're working with towns because it's got to go to approval and stuff. So they have 45 days, but by and large, it's 30 days from the moment you submit that. One of the recommendations that I often make here is, because the law says after that point in time, if they haven't paid you, then they owe you interest. I would begin keeping a tally of that. Now, the law goes into how you calculate it. It's a little bit circuitous to figure out what the current rate is. It's not an automatic rate. It's based on the prime and a variety of other things. But it's important to begin calculating those days and tallying that up as a way, frankly, for a little bit of leverage down the road. Now, at the same time, as you'll see in that final sentence before you get to the part about private work, the contractor is to pay the subcontractor within 7 days of receipt of payment from the owner. And so it's important to recognize that and make sure you're in compliance there. And there are a lot of issues to go into there. One of the cautions I make often to PMs, because I've seen folks get in trouble with that, is a subcontractor's requisition may try to put in a payment request that includes an unapproved change order. You get yourself in trouble if you don't carve that out before it goes to the owner. And I think most of you should know that, but it's important really to keep track of that time. So I want to talk about pay if paid versus pay when paid. And so, we have the timing here. We talked about that, no later than 15 days. But let's get a little bit of rationale here that I think is important to understand. And I'm gonna start this off, and then Josh may have some perspective, not just from New York State, but nationally. So in New York State, there was a case, and AGC's got some guidelines on this. And in fact, we have some language that I think you can find in the document to crunch. But in the Westfair decision many years ago, they looked at a contingent payment clause, a pay if paid clause, as being in violation of Section 34 of the New York State lien law. And so such provisions in your contract are void and unenforceable. And lack of a legally enforceable pay when paid clause, which is enforceable, may leave the contractor or subcontractor lacking of other protections. Here's the concern that I have, and I'll ask Josh in a moment to his thoughts here. But every once in a while, I will see contractors who have a national platform using within their subcontracts a national document that has not been tailored for New York, and it includes a pay if paid clause. My worry is that if you do not tailor it, or at the least, and I let actual lawyers, maybe consult on this, but if you at the very least don't have it to the extent permitted by law in there, what I worry about is that all of a sudden everything that else that you have within that subcontractor payment provision is of no value to you because you violated the first provision. Josh, your thoughts on that?
I agree. I mean, I think that those national contracts that are not adjusted for various state law provisions, which can vary across jurisdictions, that it has the potential to invalidate the entire thing, as you mentioned. So I think it's the best practice to know what's in what is required by the jurisdiction, and if that contract payment term clause aligns with that, and if it's not, to take the opportunity to adjust that.
Thank you, Josh. I want to, normally I kind of wait on the Q&A to the end, but this one kind of caught my eye. With the requisition due on the 30th of the month, assuming a 30-day pay under general municipal law, pencil copies received 25th day of the month, with receipt of final requisition on the 25th, 30th, and the 5th of the following month is payment due in all cases listed 30 days from receipt. So, the pencil requisition, is something that really, in my view, is not contemplated within general municipal law. I think it's whenever the final requisition is delivered, whether it's the 30th of the month or the 5th day of the following month, whatever day you deliver that final requisition, the 30-day clock starts ticking. Now, one of the things that I have to say that I wonder about, and I think it may require us to tighten up the language of the law, is these days with electronic submissions, you're being barred from getting your actual requisition in a timely fashion. And to me, that's finagling things in a way that's not appropriate. So something that we're going to have to take a look at, and if anyone has any thoughts or experiences with that, I'd like to know it. And with regard to the question, if I didn't quite answer that question, please follow up on that. So let's go to the next piece, and let's talk about retainage. Josh, why don't you talk about the 9.2.4?
Yes, I think that there again, it's important to know what your jurisdictional requirements are, allowances are, because on this topic, whether it's the amount of retainage that can be held when it's released, that varies significantly across jurisdictions. So I think it's important to know that up front, but document crunch is going to identify those things, provide rationale and insights again, and some sample language.
So let's look at what New York State law says, and before I get into what state finance and general municipal law says relative to retainage, I would note that under highway law, so anything with DOT, state DOT, retainage is not allowed on that to work, and that's based on federal requirements. I won't go into the history of that, but it's not allowed in any way, shape, or form. But for Section 139, State Finance Law 106B of General Municipal Law, where performance and payment bonds are required, and you'll see in the parentheses, Section 137 of State Finance Law requires at least payment bonds in nearly every case, basically any contract over $200,000. There's a little bit of nuance with Wick's law versus single prime, but figure over $200,000, a payment bond is going to be required. So when the bonds are required, the owner may hold no more than 5% retainage on each progress payment. Now, if bonds aren't required in those rare circumstances, 10% is allowed at that point in time. Now, this is an important piece here that I think people need to think about. For the most part, I think people kind of skate a little bit on this, but where subcontractors have been requested but declined to provide bonds, up to 10% retainage may be held from payments to subcontractors. Otherwise, only 5% retainage may be held. It's our view that if you never requested the subcontractor to provide bonds, and either by mutual agreement or just an absolute declining by the subcontractor to provide. They're either unable or unwilling to provide the bonds. Then you're not able to hold 10% retainage if you've never requested those bonds. And so it's something to be careful of if you intend to hold 10% retainage on your subcontractor payments. Otherwise, as I said, 5% retainage, up to 5% retainage may be held. Now, this is something also used to be, when I started in the dim and distant past with the association, it was more prevalent than before. I'm not sure exactly why it's fallen out of vogue, but under Section 139 of State Finance Law and Section 106 of General Municipal Law, a contractor, a prime contractor, is allowed to substitute negotiable securities for retainage. So they're typically bearer bonds. I think if you're with the state, it's slightly different, but it used to be, as I said, a lot more prevalent. And if your primary work is in public work, there are folks that can handle this, and those bearer bonds just kind of roll over. And as far as managing cash flow and the like, it might be a valuable tool. As I said, it used to be very, very prevalent. I don't see it as much anymore, but I want to remind folks that is available to you. Josh, you want to talk about 9.8.6 and 9.8.7?
Yes. Sorry, I can't see that very well. Yes, so this one is on the claims. Yes, so this one is going to be on your final payment. Sorry, I have a hard time seeing that. But I will just, this is, sorry, I didn't mention it before, but what I have found is if downstream parties know anything, it's about like your retainage and any limitations that are required that we're talking about. So it can create cash flow issues if you don't. It's to be aware of those things and to make sure that whether it's prompt pay, retainage, and that sort of thing, to make sure that that is aligned in your upstream prime contracts, because that's going to be an issue downstream because your subcontractors are surely going to know those things. So for example, like on retainage, having worked in jurisdictions that don't allow retainage, that is going to be something that your downstream subs are going to be very aware of. So if, like as Joe was mentioning about a national type of contract that would say call for a certain retainage or that sort of thing, that would be like a national standard. If that's something different in that jurisdiction, that's going to be something that will potentially be an issue because your cash flow. So on the 9.8 part is about the acceptance on final payment. So make sure that you know what's required to comply with the requirements to get paid. And basically all of the things that are required are going to be identified in your contract. And we at Document Crunch have made it as simple as we can to identify those things quickly, to understand what your various milestone requirements are for payment. So that's something that we have provided. Also, again, provided the rationale and insights, sample language that's tailored specifically for AGC New York. So make sure you know, it's important to know what those things are.
And a couple of things that I want to point out with this particular slide. One, the obvious, but every once in a while I hear of folks getting caught in that, so you need to know about it. Is if you accept final payment, what happens to the unsettled claims? There are often clauses that'll be even more overt than this, that a document crunch review is going to pick up. That says once you accept final payment, you're not entitled to anything more. One of the things I'm seeing of late as well in some of the documents that I'm reviewing is a clause that says, and we'll talk about substantial completion in a moment, that if you haven't achieved final completion within 30 days of substantial completion, then you forfeit all rights to any claims at all. Now, I really question whether that's enforceable, but I'd rather not go there, and I think that's something just to be aware of. Josh, any thoughts on that?
I totally agree. Like you, I mean, I wouldn't want to have to expend the time and the effort and the money to find out if that's enforceable. So if it's I was actually just reviewing a contract right before this call that had that same requirement, that you had to finish final completion within so many days of substantial. If not, you forfeit the right to payment. I, like you, Joe, I question the enforceability of that, but I would rather address it up front. If that's an issue, make sure that you know what's in your contract. And that's what we're trying to, one of the things that we're trying to empower everyone to know is what's in that contract. So you're not having to get in a situation of like arguing about whether it's enforceable or not.
The other thing I want to point out here is that 9.9 is not highlighted, but the late payment, just to reiterate what I said before, after that 30-day mark, then the late payments will bear interest. Now, a lot of times I'll see on supplementary conditions as well as supplements to the agreement, the A101, I'll see that X'd out. They can X out all they want, but the law is the law. And again, just to reiterate, keep track of that. It may be valuable for you down the road. So one of the things that AGC was successful with, and we did this in conjunction with the subcontractors, is to deal with an issue that had become rampant, more with school district projects than anything else. But the idea of when substantial completion occurs becoming stretched out, and stretching that out meant that your retainage was not released. But I want to go through the language and what the prompt payment law on public works says. Says that effectively, upon reaching substantial completion, the contractor is to be promptly paid. And again, that's for 30 days. The remaining balance of the contract, less 2 times the punch list and an amount necessary to satisfy any outstanding claims, liens, or judgments. That means retainage gets released with obviously deducting the amounts noted above. Now, the part we got changed really to clarify that is that public owners must provide the one and only punch list within 45 days of substantial completion being achieved. And if you go back to the very first sentence of that, substantial completion is to be defined in the contract. And we'll show you in a minute what the AIA document says. So everything is triggered off of that idea of substantial completion. And And so what that 45 days allows you to do is then requisition to get the retainage release minus 2 times that punch list. And that's going to have a huge benefit to get cash flow rolling. And there's even a little bit more nuance to that as we go to the next slide. So here's the typical definition that, you know, if Document Crunch is going to bring this up, it's going to show you what and you should be looking for this. What is the definition of substantial completion in the documents? And this is the classic language. Hopefully it doesn't get supplemented. But substantial completion is a stage in the progress of the work when the work or designated portion thereof, and remember that term, designated portion thereof, is sufficiently complete in accordance with the contract documents so the owner can occupy or utilize the work for its intended use. Why is that important? So obviously, beneficial occupancy is what triggers then that 45 days to get one punch list. Okay, that designated portion thereof is really important. Because if I go back to the release of retainage at substantial completion, it says release happens for the entirety of the work or for those parts of the work identified in the document. So if you have as an example, if you have an addition and renovation of a school, and this is something that we and the subcontractors really talked a lot about when we worked on that law. What would happen is owners weren't going to release any retainage until the renovation was done, even though the addition would be completed. The owner, the school, would move into that renovated work. They would have beneficial use and occupancy. And this makes it clear that once they declare that to meet the definition of substantial completion, they must provide a punch list within 45 days and release retainage for that work. And that obviously becomes really important, you know, for the early starting trades that may have nothing to do, particularly with the renovation. And I'm thinking about concrete, steel, subcontractors and those trades. And so it's significantly important for that. So really look for that definition of substantial completion. Because on public work now, it really triggers that punch list, and I don't discount the value of the requirement for one and only punch list. I think a lot of you know that it's not uncommon for a punch list to turn into a wish list, to turn into a number of wish lists, because they have different parts of the owner start walking around. And then as the facility is used for a period of time, things get damaged, and it's a question of whether it was use damage or was it a punch list item. This will discipline, or should discipline, owners and their designers to really give you, again, one punch list within 45 days of a declaration of meeting the definition of substantial completion. I don't know, Josh, if you have any further thoughts on that before I get to the Q&A.
Yes, thanks, Joe. I think that this is certainly helpful. The AI language, as Joe mentioned, like knowing what the definition of substantial completion is important. I actually like, because obviously the AIA doesn't have it, it's general, and there's no context to the particular project. Even further defining this to make it more precise, once you have the context of the project, is something I like to do. So there's no really, it eliminates the potential for dispute about what substantial completion means. Although this language in the AIA, as Joe was mentioning, is good because it's very to the point. It's about you're utilizing the work for its intended use. So as Joe mentioned, the punch list turning into a wish list, once you establish that a substantial completion has occurred, it immediately starts the clock.
One other thing, just I want to point out, put a fine point on this. What a lot of times I will see in review of the documents is there will be a definition of substantial completion, and that's what triggers the law on this. There'll be a definition as you see here, but then somehow or other they try and finagle this without changing the definition within the payment provisions of the project. That has no bearing. We fall back to the law, and as long as they've got the definition of substantial completion somewhere in the documents, that's going to be the trigger point. And so keep that in mind, and look for in the review of the documents, look for these clauses, because these are things you should know as you go into the project, because for managing the closeout of the job, managing cash flow, and getting paid as you are supposed to under the state law becomes very, very important to you. So let me look at some of the questions here. When a small amount of base scope of work, such as installation of windows, blinds, that may take a couple of days, labor once received, completes soon after the prior requisition due date, if everyone agrees that the work is complete, would the requisition submitted on the 7th, for example, be due 30 days after the 7th, or 30 days from when the contractor requisition would be due? Not sure I fully understand that, but if whatever goes into that final requisition, and if in the process you've added those pieces to the requisition, I think it goes to whenever that official requisition was put in. Now, I suppose if it's a couple of days different, would you rather argue over whether the 30-day clock started ticking a few days earlier versus not getting that piece into the requisition? I think I'd probably go to the later date, to be honest, if I had to. But it's whenever that official requisition is put in is technically when the clock starts ticking. All right, let me get to the next question. Is New York State contract have retainer clause? If yes, what is the maximum percentage? So New York State contract, again, other than the DOT work, is going to have the retainage clauses in there. It's the same with state work as opposed and local government work, that as long as bonds are required, in most cases that's going to be the case, 5% is the maximum retainage that they can hold. What are the requirements for a public agency to release retainage they've been keeping, both for partial release and final release? Is there a time frame? Well, I think we kind of went through that, and it's triggered based on substantial completion. What's interesting is that one of the reasons that we did this is we were seeing a trend toward looking to hold retainage or 2 times 1% for a year after completion. There was a suggestion about that 1% guarantee amount or something or other was a punch list item, and so it was part of the impetus for us to try and clarify this by that clear delineation to say, no, you can't just hold retainage for a year after completion or a year after substantial completion or whatever it may be. The release, it clarifies what the law had always said, which is at substantial completion, you pay the remaining amount of the contract less 2 times the punch list and an amount necessary to satisfy outstanding claims, liens, and judgments. And that had a long time been the law, but not something because it got finagled, we needed to clarify. One thing, by the way, I just want to quickly note here, is I think we've got some folks on here that do New York City School Construction Authority work. They've got, while most of this is the case, they've got an ability to hold a little bit more on the punch list. I think it's 4 times the punch list, which makes it difficult. And I apologize, I should have looked at that before, but they had a little bit more leeway on this than others. But nonetheless, they still have to do the punch list. They still have to release the retainage short of that punch list amount. The next question: if a school project includes mostly cosmetic work, a new ceiling, tile, wall painting, if the ceiling tile is complete through the painting, the painting is only 2/3 complete, the contractor begins seeking a punch list at substantial completion date. The designated portion is sufficient for the owner to occupy. How do you handle this? Well, you got to, I think, go back to the contract. So if you've got a situation, if you're just, you're rolling through a project and rooms are reoccupied when you finish them, I'm not sure that quite meets the test of when that triggers substantial completion, because again, it's based on what the contract said and what it will. And so going back to the definition in A201 on the slide that's still in front of you, it talks or designated portion thereof. So they kind of have to designate in the contract that this is a clear demarcation. I think, as I said, the clearest is going to be an addition and then renovation. When you're taking full occupancy, in a way, you could suggest, they've got to get a certificate of occupancy or a temporary certificate of occupancy to be able to do that. So I think just finishing areas of a project that then are occupied, I'm not sure quite will meet the intent of that. I suppose it's worth a try, but I think that's might be a little bit too far. Are there any superfluous items that should not be considered in determining whether the requisition is approvable? No, I don't think so. I mean, I think that, I suppose that there are items within a requisition that would stop a payment from being removed. Mostly, it's on public work typical requirements. So certified payroll, that's a requirement of law that comes with the requisition. And the OSHA cards, that's right from the get-go. If you don't provide the OSHA card, you're not going to get paid. You shouldn't even be on the project, truthfully. But certified payroll, certainly. Now the question is this: if because it's really the approvable amount. So if there's an item that can be removed from the requisition because that part's not approvable, the rest should go forward and the 30-day clock start ticking for the approvable portion of it. So if you're missing a certified payroll from a particular subcontractor and that can be clearly removed from the requisition, then I believe the 30-day clock starts ticking for everything but that one subcontractor that's missing the certified payroll. That could be a little bit dicey, right? But I think that's a possible way to go with that. But usually it's not about those items like certified payrolls. Is for certain portions that once you get through the pencil rec, you found something else. The owner found something that shouldn't have been in the requisition. You as a GC may have found something. Yeah, this one probably shouldn't have been there. Let's carve that out, but start the 30-day clock on everything else so that we don't get into difficulties. Can contractors get paid early if they submit early? No, I don't think so. I think that you're going to submit based on the contract requirements. So if the contract says that you put the requisition in 30 days, you put on the 30th of the month, you put the requisition in on the 30th of the month. If you go early, then then I don't think that necessarily starts the clock ticking, because they, I don't think that they need to accept that. But it's going to go based on the contract requirements, which are in there. And if it's not in there, which would be rare, then it's going to come on some logical, day of the month, and it can't be just done on I suppose, a whim. Is there any other recourse? And Josh, some of these are New York State stuff, but if there's anything that that you want to pipe in on, please. Is there any other recourse if prompt payment is not made by the owner other than charging interest? I don't know, Josh, what do you think? The contract, may give you other options on terminations after a certain amount of time. But what do you think, Josh?
I think from a practical standpoint, pointing out that the cash flow issues, delay issues that could occur as a result of not the owner not adhering to that prompt payment, because as I mentioned earlier, your downstream parties are certainly going to know that, might be a compelling one to convince the owner that they need to comply.
So with 2/3 complete, they are seeking 100% substantial completion as the occupancy can occur without new paint. Well, I think basically if they want to occupy it and utilize it for its intended use and get a certificate of occupancy, then I think that the substantial completion test has been met based on the definition. Now, that always leads to the question of the difference between incomplete work and punch list. But I think for the purposes of payment, it comes out the same way. I think the question is also, is it, depending on the amount of the paint and how much what the value of that is, does it become somewhat of a distinction without a difference when it goes 2 times the value of the painting portion? And then you want to, and because that also leads to a question for you, is as a GC, is what are you going to do with that painting subcontractor who and what's your ability to withhold payment from them and to make sure you prompt them to get things done timely? I think that's a bit of a management call, but I don't know, Josh, any thoughts on that?
I agree. Yeah, I think that sort of comes down to particular circumstances, as you were mentioning, and what the value of that is, and just sort of figuring. I think it's really the project specific. So yeah, I agree with what you're saying.
Is payroll certification required for services rendered as professional services? Basically, the certified payrolls are required for work that's covered by Article 8 of labor law, as I understand it. So if professional services are not covered by a prevailing wage, then no. So that shouldn't hold up a requisition of not having it on there. Although there are some other questions I think you need to think about on that in managing that whole process and some other risk areas, but and making sure that indeed what is considered a professional service isn't somehow covered within the prevailing wage. But I think in general, no, it certainly would not apply, shouldn't apply to designers from that standpoint. Now we're gonna, I've got a good deal of questions here. We're after 1 o'clock. Josh and I will stick around, keep on answering questions. Josh, if you've got the time. This will be recorded for folks as well. So it looks like we got a few more that I'll try and get to as quickly as possible. Does the final waiver of lien serve as final pay requisition for retainage, or do I complete a separate pay application for retainage? A couple of points on that. I would, once they give you the punch list, based on what the definition is, I would do a fresh requisition, on that piece. So, you multiply the items by 2 is probably something going to work through in a pencil rec to release the retainage. Now, if you've got any outstanding liens, then obviously there's a different item to cover there. A lien, I think, is 1.5 times the value of the lien can be withheld on payment. The other thing that I would note with your requisitions, it's a part of the lien law in New York. When you're from time to time, I'll see requirements that say that a waiver of lien is required with the requisition. The lien law says that you can only require a waiver of the lien simultaneous to or after payment has been rendered. So if the subcontractor has not been paid, they can't. The waiver of lien is of no consequence. Until the payment has been made. And so most of the time, the waivers are going to be required on the following requisition. Obviously, when you get to the final, it gets a little bit more complex, but there's a way to do a simultaneous approach to that. 30 days for prompt payment is date of postmark or receipt. Receipt be my view of it. And so most of the time, I would, with electronic, it's going to be easier from that standpoint, or in some other fashion, could be a hand delivery, but it's going to be upon their receipt. Let's see, choose to occupy for the 2/3 above. I think that contractors have to make the determination of when they're going to say this is substantially complete. The owner, come and take a look at it. If the owner is pushing to get in there, and obviously you've got other issues, liquidated damages, and other things to consider. That to me can be a bit of a negotiation at that point in time. And I'm not sure that in that I would be as tough on the legal niceties here, because you're probably doing that trying to avoid other liabilities. On DOT jobs where they supply an estimate and will not process payment to the contractor until they create this estimate, what is the time frame they have after cutoff to supply this to the contractor? This kind of goes a little bit to what I said before, is that when all of a sudden the agency takes control over when they're going to say the requisition has been complete and in, I think that that's something that we're going to have to take a hard look at, on that point. And it may be a matter of degree, but at the least, I would hope that there's something in the contract that says the owner's got so many days. But what's the point of doing a pencil rec if then they're going to go and do this other these other machinations that seem to me could be abused to withhold the payment, and DOT is not the only one that seems to be trying that. So we may have to work through that process a little bit and see what we can do or what we need to do to clarify this point. All right. Well, with that, I want to thank you all very much, and again, thank you to Josh and Document Crunch. These last, because of the nature of the New York State laws on these being so precise, this has been a bit more with me than with Josh, and so as we go into the new year, we're going to do some things that are a little bit more generic, a little bit less New York State law based, and the Document Crunch folks are going to get into some things that I think are of particular importance to all of you beyond what we've already covered. So stay tuned for information on that. And Brendan, do you have any other information to share relative to the recording and the whole bit?
Nothing that additional. What we'll do is we'll have this recording. We just have to edit some basic information at the beginning, and we'll have it posted up on our website, hopefully by the end of the week or early next week. So if you need to check back or send anybody there, you can certainly take a look on our website.
Great. Thanks, Brendan. And always remember, the saying, call AGC first. You have contract issues and the like, call us first. And we may on some things, we may say, oh, you know what, you might want to have a document crunch, take a good hard look. Have their algorithm take a good hard look at the document and identify some of these things. This is, as I said, a real tool to help you better manage your business. So thank you all very much.
Thank you.